all the way, or they've acquitted?
Well, the time involved would lead one to that decision. But on the other hand, if they were able to decide so quickly on guilt or innocence, why would they not also be able to decide that Goldman, for example, was a case of second-degree murder? It's asking a lot of a jury, unsophisticated in the law, but this is a jury that's about as professional a jury as any we're ever going to see. Nevertheless, the time spent on deciding, on making their decision, certainly does indicate either straight acquittal or a straight conviction, probably a first-degree murder.
Now, of course, all the way through, we've looked at the composition of this jury, and we've basically concluded that because there are 9 blacks, 2 whites, and 1 Hispanic, that they're almost certain to come down on thinking that O.J. Simpson is probably innocent, because they've got to go back and live in their communities afterwards. We said this, didn't we, throughout. Do you think that's perhaps underestimating their intelligence?
I do. I think that this jury has not necessarily decided this case on the basis of race. I think that they have become very sophisticated and determined to do what is right. Of course, we don't know this. This is only our interpretation, but these seem to be a very hard-headed bunch of people here, and I think that whatever the verdict is, it's one that they will have honestly have believed in, regardless of how short a time it took them to come to it.
We know that Gerald Ullman and Alan Dershowitz have been working on grounds for appeal almost from the outset of this trial. At what stage does that process start?
The moment there is a conviction, that appellate brief will begin to be finalized. And within a month, I am sure, the appellate brief, which will be very lengthy, have any number of appellate issues, will be completed and submitted to the California appellate courts.
And, I mean, when we look at the length of this trial, how long might an appeal take?
Well, I think given the visibility of this case, the appellate court might expedite their decision in the case. So it might not be as long as the normal appellate case. How long would it be? Anybody's guess. I would say less than a year, more than 6 months.
Gary, for the moment, thank you very much.
Well, let's show you a rather familiar sight from the courtroom. There it is, the court shield, with what, let's see, 7 minutes to go until we expect everybody to start filing into that courtroom for the verdict. And now we're going to cross back to Christopher Morris outside the courthouse. Over to you, Chris.
Hello again, Vivien. The situation at the moment is that the crowds are getting bigger and bigger, noisier and noisier. Demonstrations obviously going to be likely once that verdict becomes known to everybody here outside. But I have a guest with me now, Paul Greenwood, formerly a solicitor in England, who is now in fact a deputy district attorney in California, in San Diego. Paul, you've been studying this case, obviously. How do you think it compares with the British courts?
Well, it's certainly very different, and in fact every case over here seems to be very different from the way we conduct business in the courts in England, but particularly this case has had everything in it, including the personalities, the drama, and the crooked cops.
What about the effect, though, on the American legal system? Do you think it's done them a sort of bad turn, because this has dragged on for 9 months? People are getting pretty fed up with some of the things that have been going on in court.
Certainly, I think this is why this verdict today is so important. Either way, if it's a guilty verdict, then the people are going to really reconsider how they prosecute cases. I mean, to spend 8 months on a case to find that a jury only deliberates for less than a day is certainly going to make people reevaluate their strategy. If it's a not guilty verdict, then again, for the prosecution, they're going to have to reevaluate a lot of things, and particularly if the race card has played an important part in the decision of this jury. So whatever the decision comes down today, it's going to have ramifications for the criminal system here in California.
Now, as a deputy district attorney here in California, how do you think this verdict is going to come out today?
Well, when I heard yesterday that they had asked for a readback of testimony, and we didn't know who the witness was that they wanted to read back, I said to one or two of my colleagues, I hope it's Alan Park. Because for me, all along, Alan Park has been the crucial witness for the prosecution, because he has no axe to grind. He was there on a business. He can define the time when he was at the house, when OJ wasn't there. And he was crucial. So when I heard that it was Alan Park, instinctively I felt that this was a positive sign for the prosecution. And the fact also that the jury did not ask for the cross-examination testimony to be read back to them. But since then I've heard other people give other viewpoints on that, but I still have got this feeling that it's going to be a guilty verdict based upon the choice of Alan Park.
Obviously, a view that is held by some. Gil Garcetti, though, the district attorney here, is not quite so sure. He's not putting all his money on it at this stage.
Well, that's right, because you simply cannot. And one thing I've learned over 2.5 years prosecuting in California, you can never predict or second guess what a jury is going to do, and it would be foolish of anyone to do that. So it could go either way, obviously, and the pundits have had a field day overnight to give you their expert opinion as to which way they think it's going to go. But until that verdict is read, until we hear from the jury, then we don't know. Interesting enough, if it is a guilty verdict, and obviously the jurors then speak about the verdict afterwards, that in itself can give grounds to the defense for an appeal, because based upon the criteria that the jury uses to come to their verdict, that in itself can actually set aside a conviction.
And we have had jurors talking openly, those that have been dismissed from that panel already. We've had books and audio tapes and everything.
Yes, and in California there's nothing to stop a juror from speaking freely. At the end of any criminal trial here, the judge says to the jurors, now, you don't have to speak to anybody, but then again, you don't not have to speak to anybody. And often we as prosecutors like to talk to the jurors afterwards, particularly if it's a not guilty verdict, to find out what the problems were for the jurors. But that does have its risks when it's a guilty verdict. If you're speaking to them and they tell you things that really they should not have considered, and that can leave open the door.
So do you think there's a big gulf between American jurors and British jurors?
Well, there's a gulf in terms of the selection of the juries. As we know in England, apart from challenges for cause, in rare circumstances, it's the first 12 into the box. Whereas here, there is such a selection of voir dire process that one goes through, both for the prosecution and the defense. I mean, I'm handling 3 strikes prosecutions, and each side, I and the defense, have 20 challenges each. So sometimes it takes an awfully long time to get to a jury. But that's just one aspect of how trials differ. I mean, I could point out other differences too as we go along the way.
Okay, just a few minutes to go. Paul Greenwood, thank you very much for that interesting discussion. Now back to you in the studio, Laurie.
Okay, thank you very much indeed, Chris. Gary Solis is still with me. Interesting hearing from another San Diego man.
Yes.
Now, let's just remind ourselves of the composition of this jury. We were saying a moment ago that there are 9 blacks, 2 whites, 1 Hispanic, 10 women and 2 men. Does the preponderance of women tend to mean anything on a jury, Gary?
Well, of course, those who read the tea leaves about jury selection think that it does. They feel that women would tend to be sympathetic toward the victim in this case who suffered domestic abuse. So both sides were angling for something, of course, when the jury was selected. The number of blacks was pleasing to the defense, the number of women was pleasing to the prosecution. And that is the balance that was finally reached, the equilibrium that they were finally satisfied with.
But you're satisfied in your own mind, are you, that race won't actually be that big a factor when it comes to deciding guilt or innocence in this case?
I would like to think that that is the case, that it will not be determinative, that instead it's going to be the issues raised in court and the evidence presented that determines the case. But obviously we're not going to know that until we have the first few jurors publish their articles and books.
But of course the overwhelming evidence from the opinion polls is that something like 3/4 of blacks still think that he's innocent and 3/4 of whites think he's guilty.
There's no question about that, but of course those opinion polls are taken among those who have not heard that much of the trial, haven't listened to the evidence, and as we've said before, there's only one opinion poll that matters, and that's the one we're about to hear.
Okay, speedy decision from them, which could indicate that they've gone for first-degree murder. Now, if it is first-degree murder, there are special circumstances here, aren't there, which say that this is life without parole?
Exactly. First-degree murder alone does not mandate life without parole. The sentence for first-degree murder is 25 years to life. However, there are special circumstances in the California Penal Code, 19 in number, that if alleged by the state, and one has been alleged by the state, can, if satisfied, lead to life without parole. And in this case, multiple murder is the special circumstance that's been alleged. The jury will have to say, along with their verdict, we find the special circumstance of a multiple murder. So if there is a first-degree murder combined with a special circumstance, in this case multiple murder, then the judge will have no choice. He must impose a sentence of life without the possibility of parole, and in California it means just that.
Of course, there are still people who are saying, why isn't the death sentence applicable?
And that's because the case was referred to trial as a non-capital case, a decision made by Gil Garcetti, the district attorney and the chief law enforcement officer of Los Angeles County. The reason he made that decision is because he was confident that if death was facing O.J. Simpson, or O.J. Simpson was facing death, no jury would convict him, because no jury was going to see Santa Claus or the Tooth Fairy or O.J. Simpson go to the gas chamber or electric chair in California.
A lot of it has been made, hasn't it, in the past day, of the fact that when they came back yesterday and said to Judge Ito, we have a verdict, they didn't look at O.J. Simpson. Now, is this averting of the eyes significant in your experience or not?
In my experience, it's very significant. Whenever, of course, I was a prosecutor, and whenever I saw the jury not look the accused in the eye, I was always confident that the verdict would be guilt. But in this case, I don't think we can be so sure. As Mr. Paul Greenwood just said a few moments ago, we really don't know what the verdict is going to be in this case. We're guessing. We think that it's going to be guilt, but we really don't know because this jury has been a very closed-mouthed, stone-faced jury. They've kept things to themselves. They know that all eyes are on them, and they're not going to give away anything until the moment they read that verdict.
Well, just a reminder, Gary, that we have, in fact, just passed 6 o'clock. We're just a few seconds past, but we're not missing anything. There's absolutely no feed from the courtroom at the moment. The minute, of course, the action does begin there, we will go there live and we'll hear it all without interruption from us, and then, of course, we'll come back to Gary and our various experts for their comments. The speed with which all of this was decided took Johnny Cochran clearly by surprise because he'd gone for a long weekend in San Francisco with his family, hadn't he?
I don't believe there's anybody who was not completely taken by surprise. It was absolutely astounding. I was in bed last night after...
Okay, Gary, we're going into court, so let's go straight in and see what's happening. Here's Judge Ito.
All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Kardashian, Mr. Bailey, Mr. Blazier. People are represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Good morning, counsel.
Good morning, Your Honor.
All right, the record should reflect that earlier this morning at 9 o'clock, the court met informally with counsel here in the courtroom because there are too many lawyers to go into chambers this morning for the purposes of discussing notifications to the jurors regarding their rights of privacy and the interest of the news media to interview them or speak to them following the delivery of the verdict in court here today. The court distributed to the parties copies of the questionnaire that has been distributed to the jurors, and also the notice to them regarding confidentiality under 237 of the Code of Civil Procedure. And those two questionnaires have been returned by the jurors. They have uniformly indicated their desire that their private information will remain confidential. They have also indicated to the court unanimously a desire not to speak to the attorneys after the conclusion of the trial, and not to speak with the news media either. All right, counsel, is there anything else we need to take up before I invite the jurors to join us? All right, Deputy Trower, let's have the jurors, please.
Ready, Gary? Who's that? Oh, Kardashian.
Well, while we get the jury back, Gary, let me just ask you, that request from them not to have to speak to attorneys or the news media afterwards, is that fairly common?
No, it's not common. Usually jurors are willing to speak to the lawyers particularly, and usually there isn't any media interest to be concerned about. But in this case, this jury is continuing its closed-mouth, stone-faced countenance by not giving out anything more than they have to. They know they're going to be besieged in their own homes and their relatives' homes when they leave the courtroom, but nevertheless, they are not going to voluntarily make a spectacle of themselves, and I think they're to be congratulated for the decision in this regard.
We heard Judge Ito allude to the number of lawyers involved in this case. Can you just remind us how many there have been? Because there's been a huge number on both sides, hasn't it?
There have. There have been 12 principal in-court lawyers for the defense. There have been any number working in the background in the offices that we've never seen, some that were working in South Carolina. For the prosecution, there have been 12, as it happens, also principal in-court lawyers, and in addition, there have been another 42 reportedly working on this case upstairs in the criminal courts building in the district attorney's office.
Okay, we're back in court.
And the record should reflect that we have now been rejoined by all the members of our jury panel and our alternates. Good morning again, ladies and gentlemen. All right, Mrs. Robertson, would you, do you have the envelope with the sealed verdict forms, please?
Yes, Your Honor.
All right, would you give those to Deputy Trower? And would you return those to our four-person juror number one? All right, Madam Foreperson, would you please open the envelope and check the condition of the verdict forms. All right, Madam Foreperson, you've had the opportunity to review the verdict forms.
Yes.
Are they the same forms that you signed, and are they in order?
Yes, they are.
All right, would you hand those, please, to Deputy Trevor? And you have signed and dated those verdict forms indicating the jury's verdict?
Yes.
All right, thank you. All right, ladies and gentlemen and of the jury, I'm going to ask that you carefully listen to the verdicts as they are being read by the clerk, Mrs. Robertson. As after the verdicts have been read, you will be asked if these are your verdicts. And I would caution the audience during the course of the reading of these verdicts to remain calm, and that if there is any disruption during the reading of the verdicts, the bailiffs will have the obligation to remove any persons disrupting these proceedings. All right, Mrs. Robertson. All right, Mr. Simpson, would you please stand and face the jury? Mrs. Robertson.
Superior Court of California, County of Los Angeles, in the matter of the people of the state of California versus Orenthal James Simpson, case number BA097211. We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Nicole Brown Simpson, a human being, as charged in count 1 of the information. Superior Court of the State of California, County of Los Angeles, in the matter of the people of the State of California versus Orenthal James Simpson. We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Ronald Lyle Goldman, a human being, as charged in count 2 of the information. We, the jury, in the above entitled action, further find a special circumstance that the defendant, Orenthal James Simpson, has in this case been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree to be not true. Signed this 2nd day of October 1995, Juror 230. Ladies and gentlemen of the jury, is this your verdict? So say you one, so say you all.
Yes. All right, counsel, Mr. Simpson, would you be seated, please? Have it quiet in the courtroom, please. All right, Mrs. Robertson, would you please poll the jurors?
Poll the jurors. Juror number 1, as to count 1, is this your verdict? Juror number 2, as to count 1, is this your verdict? Juror number 3, as to count 1, is this your verdict? Juror number 4, as to count 1, is this your verdict?
Yes.
Juror number 5, as to count 1, is this your verdict? Yes. Juror number 6, as to count 1, is this your verdict? Yes. Juror number 7, as to count 1, is this your verdict? Yes. Juror number 8, as to count 1, is this your verdict? Yes. Juror number 9, as to count 1, is this your verdict? Yes. Juror number 10, as to count 1, is this your verdict? Yes. Juror number 11, as to count 1, is this your verdict? Juror number 12, as to count 1, is this your verdict? Okay, count 2. Juror number 1, as to count 2, is this your verdict? Yes. Juror number 2, as to count 2, is this your verdict? Yes. Juror number 3, as to count 2, is this your verdict? Juror number 4, as to count 2, is this your verdict? Yes. Juror number 5, as to count 2, is this your verdict? Yes. Juror number 6, as to count 2, is this your verdict? Yes. Juror number 7, as to count 2, is this your verdict? Yes. Juror number 8, as to count 2, is this your verdict? Yes. Juror number 9, as to count 2, is this your verdict? Yes. Juror number 10, as to count 2, is this your verdict? Yes. Juror number 11, as to count 2, is this your verdict? Juror number 12, as to count 2, is this your verdict?
All right, the clerk is directed to record the verdicts as read. The parties agree to waive reading of the verdicts as recorded. Mr. Cochran, do you waive reading of the verdicts as recorded? Yes, Ms. Clark. Thank you. All right, ladies and gentlemen, I want to at this time take this opportunity to publicly thank you for the service that you've given to us. The burdens that we've placed upon you were enormous, and words can't begin to express the debt that we owe to you for the time, patience, and exertion that you've given to us during the course of this case. I will have an opportunity to meet with you privately later, and I'll give you my private comments when we have a chance to meet. I want to caution you at this time that there is, as you know, intense media interest in this case. The news media will probably seek you out at your home or at your place of business. And I would implore that the news media act responsibly to avoid harassing you or identifying you without your consent or otherwise causing you concern. Whether you wish to cooperate with the news media is, of course, entirely up to you. However, I must warn you to expect the worst as far as that is concerned. We want to, I know I share with you in expressing our thanks to the bailiffs from the Sheriff's Department, to our court reporters, Ms. Moxham and Ms. Olson, to the research attorney, John Byrne, who's assisted us, our Pepperdine law clerks, Mr. Golub and Ms. Carswell, our media liaison, Jerry Ann Hazlett and her staff, and of course the jury commissioner, Gloria Gomez, and her staff. All right, counsel, is there anything we need to take up before we excuse the jurors, Mr. Cochran?
So there we have it. O.J. Simpson has been acquitted after 15 months in custody. Joining me, Gary Solis, who gave me his own sealed verdict a week ago, which I've just opened, and which reads, not guilty. And you said this would happen, Gary, within 4 days of getting the case. Well, you did pretty well on that. This has staggered me, I have to say.
Ladies and gentlemen of the jury,
let's hear what Ito's saying.
I'm now going to excuse you from further service on this case. As you know, this does absolve you from your vows of silence. You may take with you your juror notebooks as you have requested, and we'll be chatting with you shortly. All right? Thank you very much, and I'll see you all later. All right.
So there's the scene in the courtroom. O.J. Simpson has been acquitted, as predicted by our expert here, Dr. Gary Solis. Gary, clearly you are not surprised because you predicted it, but why do you think he's been acquitted?
I don't think there's any one reason. I think it's an amalgam of reasons. The incompetence of the police laboratory, their failure to take even the observe the most basic precautions in their evidence.
We're seeing just very distressed scenes in the courtroom.
Ms. Clark. All right, the defendant having been acquitted of both charges, he is ordered transported to an appropriate sheriff's facility and released forthwith. All right, we'll stand in recess.
Please clear the court.
Right now.
And that means he will, Gary, be released immediately, does it?
Immediately. He'll go back to his cell, the one he's been in for 15.5 months, pack his gear, and return to his home on Rockingham.
Now, of course, we've seen considerable distress in the courtroom there. Goldman's family
Naturally.
in tears, quite understandably. But, of course, their action, their civil action, continues.
Their action and that of Ron Goldman's natural mother continues as well. And there has been one filed by the family of Nicole Brown, if I'm not mistaken, and I expect that there will be several other civil actions. So as pointed out earlier in our coverage, Simpson's problems are far from over. Not only that, but since the standard of proof in a civil action is lower than that of a criminal action, the possibility of loss is greater. Loss to Simpson, that is.
Financial loss of very considerable proportions.
Correct.
What are we talking? Hundreds of thousands, millions of dollars?
Millions of dollars, yes, possibly so.
And how long will these actions take to be resolved, do you think?
Probably years. The waiting list on civil actions in Los Angeles is, on a clear day, you can sue forever, they laughingly say, is quite lengthy. So I would think that these will be going on for years and will be a drag on his fisc.
So it isn't all over for O.J. Simpson by quite a long chalk yet?
No, but on the other hand, I'm sure he'd rather be in this position facing civil charges or civil cases than facing what the alternative was in the criminal court.
Okay, for the moment, Gary, thank you very much indeed.
Well, now we can speak to Christopher Morris, who's outside the Los Angeles courtroom. Chris, the reaction where you are?
Well, the reaction here is still one of celebration. There were obviously very gloomy faces earlier on this morning, about 3 hours ago, when people were arriving, talking about demonstrations if he was found guilty, but everyone here had been tuned in either to television sets or radios, and when that moment came, when the jury announced the verdict, it was quite astonishing.
What springs to my mind anyway, Chris, is the words of one of the dismissed jurors who came out and said she found the prosecution case a whole lot of nothing.
Well, I think one of the problems with this case has been the sheer length of it, the fact that the jury have had to sit through almost 9 months of testimony, and they became bored. They stopped taking notes. They stopped indeed paying a lot of interest to what was going on, particularly during the forensic evidence. Now, the prosecution were pinning their case on that. It was a circumstantial evidence case, but they felt their evidence forensically was strong enough to convict. Clearly, the jury didn't think that. Well, let's find out a view of one of our other experts throughout this trial, Professor Robert Pugsley from the Southwestern University of California. Bob, your immediate reaction to this verdict?
Chris, I guess it proves the conventional wisdom. If the jury does come back with a quick verdict, it is an acquittal. That's all I can really say about this. I don't think the jury deliberated in any meaningful sense of the term, and I said that would be true whichever verdict they reached. They were in there for 4 hours. This was a 9-month case. I don't think they could have possibly looked at any of the DNA evidence or any of the other relevant evidence. If they did conduct any meaningful discussions, they must have been in spite of the judge's orders during their sequestration of the hotel. 4 hours is a travesty. That's all I can say.
Indeed, there were something like 40,000 pages of testimony?
50,000 pages, hundreds of exhibits, days and days of testimony. The jury was misutilized in terms of its time. They were made impatient. But there's just no conceivable way that they could have possibly considered the evidence, and I would say that if the verdict were guilty. It's a preformed judgment on my part. They decided they wanted to get it over with. They'd had enough. They had their bags packed. They're ready to go home. They had weekend plans, and they're out of here, and it's all over right now.
So what was the purpose yesterday, do you think, of reading back the evidence of Allen Park?
I have no clue. Maybe to provide a facade for an already made decision. Maybe they didn't want to play cards for 3 days in the jury room and keep up cover. Forgive me for being cynical, but I just think that this is $9 million worth of nothing.
And what do you think it's going to mean now, as we've always discussed this problem? What's it going to mean for the American legal system?
Well, it's too broad for the American legal system. I think the immediate consequence here is for California. Does Mr. Garcetti, who promised that even if it were 11-1 for acquittal, well, of course he has no choice now. It's a complete acquittal, no hung jury. I mean, it's the end of the line for him politically. There'll be massive repercussions in the DA's office. I think that sequestration will be resigned for the future for truly worthy cases where jurors are in danger of death. I think we've given lie to the fact that you can containerize press coverage of a case. The jurors probably knew from the very beginning what was going on outside, had regular reports via the family visits. I think, in short, it demonstrates again that a wealthy defendant in the United States of America, whether white or black, has equal opportunity to beat the justice system, and O.J. Simpson did it.
Shattering for the prosecution, particularly for Marcia Clark. She had done 20 murder cases, never lost one. She looked absolutely devastated in court just now.
She is devastated. She'll survive. I'm more concerned about Fred Goldman and the families of these people who are thoroughly convinced of the defendant's guilt and who are left with the emotional outrage that they have to somehow work off and bottle up.
The LAPD, the police department, it's an indictment of their behavior, the way they carried out their investigation, the corruption allegations, the frame-ups, and so on.
Most certainly, and beyond the corruption, the frame-up, and the racism of Mark Furman and the lies of Van Adder, it's also an indictment of the absolute incompetence and sloppiness of the criminalists, the coroner's office, and the rest of it. And what we've had exposed under the Klieg lights of this defense team that was well fueled by Mr. Simpson's money is the absolute second, third-rate performance that we get out of our system on a daily basis, and for which many people are behind bars today. Again, money talks, the defendant walks. Whether Mr. Simpson is guilty or not in any moral or empirical sense, I don't know, and it's almost besides the point at this stage. What has been demonstrated is the incompetence, the lying, and in part the racism of the LAPD, and I think that was probably persuasive with this jury.
And at the end of the day, when that verdict was announced just a short time ago, the two victims who were brutally killed, there's no doubt about that, there were pictures to show what exactly happened to them, they're forgotten.
Completely. They will be remembered only by their families. This crowd will be dispersed. This crowd has no interest in those two people. They have interest only in the spectacle of the moment, as does the media and all of us here. The remembrance of the true victims of this crime will be left to the privacy of their families. And the discussion of this case is...
Now, finally, Bob...
can I finish my answer or not? Oh, thank you. Okay. The responsibility for this case, I think, will be debated in books, in conspiracy theories, and so forth for the next many, many years to come.
Okay, Bob, for the moment, thanks very much. Let's hand you back now to Viv in the studio in London.
Thanks very much, Chris. So, after more than 8 months, the jury has cleared O.J. Simpson. Our reporter, Anna Botting, has been looking back at how the defense won its case.
After his arrest, O.J. quickly gathered together his so-called dream team of attorneys, experienced, expensive lawyers like Johnny Cochran, F. Lee Bailey and Robert Shapiro. They turned out to be his best investment. The prosecution took 6 months to present its evidence. During that time, the defense proved relentless, grilling witnesses, casting doubt on their testimony.
So did you lie when you didn't tell me about that dream?
I sure did.
You did?
You had some problems with alcohol in the past?
Yes. The prosecution presented DNA evidence linking Simpson to the crime scene, but the defense claimed it was unreliable, contaminated by sloppy police work and incompetent forensic staff.
That's not you, grasping the envelope with the prescription glasses with your bare hands. What, pray tell, is it?
The prosecution's claim that Simpson had worn 2 dark gloves to commit the murders floundered when he struggled to put them on in court. By July, the defense began to present its own evidence, showing O.J. Simpson was not a jealous killer, but a family man devastated by news of Nicole's death.
He was very upset. He was crying. He was saying, Arnell, I don't understand.
Well, you can't tell us what...
Sorry. Okay. He was saying, he was very upset and emotional.
With no eyewitnesses, prosecutors said the murders occurred around 10:15, when Nicole's dog Cato started barking. Plenty of time for Simpson to return home and get ready by 11 for a flight to Chicago. But defense lawyers called their own witnesses, who'd heard nothing at that time.
It was exceptionally quiet. As long as I've lived in that home, I never remember a night when it was absolutely still. There wasn't a sound to be heard.
The defense then turned to what became the most crucial part of its case, Detective Mark Furman. O.J.'s lawyers had always claimed he was a racist who'd set out to frame Simpson after meeting him on a domestic violence call-out 9 years earlier. On the stand, he denied it.
Do you use the word nigger in describing people?
Presently.
Yeah. Oh,
no, sir.
But after a tip-off, O.J.'s lawyers got hold of the infamous Furman tapes to prove him a liar. Recorded by screenwriter Laura Hart-McKinney, they showed Furman using the word nigger 41 times.
First thing, anything out of a nigger's mouth for the first 5 or 6 sentences is a lie.
The reputation of a key prosecution witness was in tatters. After 8 months, O.J. finally spoke out, though not in the presence of the jury.
Did not, could not, and would not have committed this crime. I have 4 kids, 2 kids I haven't seen in a year. They ask me every week, Dad, how much longer?
O.J.'s lawyers gave a spirited and powerful finale, pouring scorn on the prosecution's evidence.
Somebody played with this evidence.
Someone has taken these children's mother. I certainly hope that your decision doesn't take their father.
O.J. Simpson, imprisoned for 15 months, can now walk free. Anna Botting, Sky News.
Well, joining me now in the studio is the barrister who's been a guest with us here on Sky News during this trial, Martin Ford. Good evening, Martin.
Good evening.
Your reaction, first of all?
I'm not surprised at all. I thought that the swiftness of the verdict indicated that they were likely to acquit. I was slightly thrown by their request to listen to the evidence of part, because I thought that that was really difficult for the Simpson team to deal with as far as alibi was concerned, and that was perhaps a bit of a red herring.
Well, some people are saying perhaps one person on the jury was a little bit worried about that and was inclining towards guilt and wanted to verify what he or she thought.
There may have been some slight inconsistency that the others remembered that somebody didn't accept. I mean, all I can think of is his hesitation as far as whether or not he'd actually looked for the Bronco, and he said that he hadn't looked specifically for it. But in another sense, his evidence ought to have been devastating. He was very conscientious, he turned up early, he kept a close watch on the house, he was looking to impress this rather important client. He says he saw somebody go towards the house, he saw lights go on, he rang the bell, Simpson comes downstairs, says he's overslept. Marcia Clark, I thought in her presentation at the end of the case, was very good when she talked about time frame. She dealt with it extremely well. But I couldn't really see those jurors going back into their communities after 4 hours, after 9 months of evidence, and saying we convicted him having considered things carefully. I heard what Dr Pugsley had to say. I mean, he's obviously enraged that the system can produce a result like this, and it doesn't look as if the jury were particularly conscientious, but they must have been making their minds up and discussing it throughout the trial, which they would be allowed to do here. There wouldn't be the sequestration every night. The juries only find themselves confined once they go away to consider their verdicts, and neither would they be expected they'd be told not to speak to partners, but you would expect in a trial such as this, for instance, the Simpson statement to have been communicated to jurors whenever they met their partners, and what he had to say about his innocence.
Martin, thank you for the moment. Don't go away. We'll be back to you a little later.
Indeed. So if you haven't heard the news, you will have gathered it by now that O.J. Simpson has been acquitted. We'll have more on the verdict in just a moment.